Hi, everyone. Welcome to the January 2025 NA webinar. Really appreciate everybody joining us live today. And we got a really special guest, Amanda Carr, that's going to speak about the Endangered Species Act and some updates and information there. I think it's going to be a really great topic. Just a little housekeeping before we get started. Everyone's on mute and videos are off for right now. If you have questions for Amanda, you feel free to type those in the chat box as we move through the presentation. And then at the end of her presentation, we'll go ahead and open it up for Q&A. So I could read off those chat box questions, or feel free to raise your hand at the end and we can take questions like that and just take you off mute. Before we introduce Amanda, I just want to say thanks to this month's webinar sponsor, Bierman Equipment. Bierman sells specialized aquaculture composters, digesters, and incinerators. So I dropped their webpage link in the chat box. Again, really appreciate Tim for sponsoring this webinar. So you guys check them out. So with that, I'd like to introduce Amanda Carr. She represents private, public, and nonprofit clients in the environmental, natural resource, climate, and land use matters. She counsels clients in strategic planning, project permitting, policy development, regulatory compliance, emerging and established ecosystem markets, natural resource damage assessments, and enforcement actions under federal, state, local laws and regulations, including the Clean Water Act, Endangered Species Act, Clean Air Act, Oil Pollution Act, and national and state environmental policy acts. Amanda frequently serves as both advocate and project manager for complex projects, including those that require regulatory approvals from or coordination among multiple agencies, and also represents clients in the administrative and judicial litigation. Her clients include shellfish aquaculture farmers, state agencies, mitigation and conservation bank sponsors, ecosystem market investors, nonprofit organizations, industry associations, and commercial and residential landowners and developers. She's the founding partner of Pollution Car LLP, a natural resource and environmental law firm established in 2009. And they have offices in Seattle, Washington, Baton Rouge, Louisiana, and Minneapolis, Minnesota. So, Amanda, we really appreciate you being here and offering some legal expertise for NA's members. So, with that, feel free to share your screen and we'll hand it over to you.
Thank you, Charlie. Let's see if I can get this up here. All right, can you see my screen and can you hear me?
Yeah, both look good.
Great. All right. Well, good morning or good afternoon, depending on where you all are zooming in from. And thanks, Charlie, for the great introduction there, and thanks to NAA for having me today. I won't give a lot of more information about my background, but I'll just note, kind of for context for this presentation, I have been working with shellfish growers in my practice since 2006. I'm based in Seattle, Washington, so some of my perspective and experience, from today really comes from that background. As Charlie mentioned, I also do work in kind of ecosystem markets, ecosystem services, restoration, conservation, and natural resource damages. The Endangered Species Act comes up in a lot of those contexts. And I know it comes up a lot for aquaculturists as well in a lot of different ways. So some of those ways I've got some experience on, and some are not as familiar to me, but I have some level of awareness of them. And I don't represent NAA. I'll just kind of put that out there for folks' awareness. I do work with and represent shellfish farmers on the West Coast. So today I'll do an overview just of the Endangered Species Act for folks that aren't as familiar with kind of with the structure of the act. Talk about some recent developments in rulemaking and litigation, and then talk about some emerging trends or active issues and different approaches that aquaculturists have taken to ESA consultation under Section 7 of the Act. And I gave a presentation. I've given presentations on the Endangered Species Act at the Pacific Coast Shellfish Growers Association conference in 2023 and 2024. And then Charlie was at the 2024 conference and saw my presentation and asked if I'd come do a webinar through NAA. So that's what brought me here today. And my presentation's about 40 minutes. I am aiming to leave some time for Q&A at the end. And with that, I will dive in. So the Endangered Species Act has been around for over 50 years. It was passed in 1973. It protects endangered and threatened species and their habitats in the United States. And I'll just go over some of the major provisions. There are others. I'll focus really mostly on the first two in my presentation today. And there are two agencies, NOAA Fisheries and the U.S. Fish and Wildlife Service, which are referred to collectively as the services, who share responsibility for implementing the Endangered Species Act. NOAA Fisheries is responsible for most marine and anadromous species, and the Fish and Wildlife Service is responsible for terrestrial and freshwater species, as well as several marine mammal species. And there are a few species the two agencies share jurisdiction over. Section 4 covers listing, delisting, and reclassifying species, designating critical habitat, also developing and implementing recovery plans for listed species, and monitoring and evaluating the status of listed species, and in some instances, delisting. Section 7, which many growers probably have dealt with in the permitting context, addresses consulting on federal actions that may affect a listed species or its designated critical habitat. That's through the permitting process. And then Section 10, cooperating with non-federal partners to develop conservation plans, safe harbor agreements, and candidate conservation agreements with assurances for the long-term conservation of species. A little more information about the, under Section 4, the listing process. So there are a list of factors that are up on the screen here. Hopefully folks can see them, 5 factors that are considered in listing species. For those that are not able to view the screen, just briefly, it's present or threatened destruction, modification, or curtailment of its habitat or range, overutilization of the species for commercial, recreational, scientific, or educational purposes, disease or predation, inadequacy of existing regulatory mechanisms, and other natural or man-made factors affecting its continued existence. And then on the right is just a graphic that shows the process for listing, how a species is kind of brought to the attention to the services for listing. If it's through the petition process, there are other ways to have a species listed. So if the service takes an action on their own, I'll just highlight there are opportunities for public comment throughout the process. Just a few on the species listing front, kind of active, ongoing, or issues that have arisen related to aquaculture. I don't have direct experience with all of these, so I just want to highlight them for folks. I think many are probably on this webinar are probably aware of them already, but one is the listing of foreign or non-native species. So the Endangered Species Act allows for the listing of species that are not native to the United States, as well as this kind of issue of having a species, when it's determined that a species is threatened or endangered, determining what portion of its range the species is endangered or threatened. And sometimes that is a specific geography that's a subset. Sometimes there's a general where listed, wherever found designation that's pretty broad. It's just wherever the species is found. So there are some implications there, can pose a challenge when members of that species are kept in captivity. And then last on here is just an example of, but a new listing for species and how that can affect aquaculture. The sunflower sea star is just an example of a species on the West Coast. It's come up in some conversations with the services, talking about sort of things on the horizon. The sunflower sea star was proposed for listing in 2023, so it has not yet been listed. But just the new listing of a species can have some effects there. Turning to the Section 7 consultation process. Section 7 requires federal agencies. So when you see that federal action, that includes any federal agency issuing a permit. It's not an action necessarily that the agency directly takes in terms of a project. If they're approving a permit, that triggers a requirement for ESA consultation. So in many instances, that federal agency for aquaculture is the Army Corps of Engineers. Any other federal agency would meet that requirement as well, but they're required to consult with the services on permit applications for proposed work that may affect threatened or endangered species or their designated critical habitat. And so the process when you're determining the effects of the action, that action agency makes a preliminary determination. That can be no effect is one option. That really means there's no effect on ESA listed species. And then there's no Section 7 consultation. If there's a finding of may affect, but not likely to adversely affect, that means that the effects are expected to be beneficial, insignificant, or extremely unlikely to occur. There's an informal consultation that happens in that circumstance, and the action agency has to get written concurrence from the services on a not likely to adversely affect conclusion. And then the last category is in the instance of formal consultation, that bottom right bubble on the screen there, which is the may affect and is likely to adversely affect determination. That means that the listed species or critical habitats are likely to be exposed to the action and to experience negative responses. And that in that situation, formal consultation is required. As an outcome of that process, the services issue what's known as a biological opinion. If there's a conclusion that the project's not likely to jeopardize the continued existence of any listed species or destroy or adversely modify critical habitat, and there is expected to be some level of take, there's an incidental take permit issued, and that amount of take is quantified. The biological opinion includes reasonable and prudent measures, or RPMs, and terms and conditions to minimize and monitor impacts to listed species. And the services have made some recent changes related to those RPMs that I'll talk about later on in my presentation that allow the services to require mitigation through RPMs. If there is what's known as a jeopardy or adverse modification conclusion, then the biological opinion specifies what's known as reasonable and prudent alternatives, or RPAs, that have to be taken to avoid jeopardy or adverse modification. RPAs can include mitigation requirements, and that's been the case for quite some time. Give a little overview of some approaches to ESA consultations that growers have taken on the West Coast. So both Washington and Oregon have what is known as programmatic consultations covering shellfish aquaculture activities in those states. Washington's is designed for 20 years. To last for 20 years. It was completed in 2016. It's really been instrumental in providing some stability and predictability for growers in the permitting process. It's also been helpful in other permitting processes because it's a document that really thoroughly evaluates effects of actions. that can, I think other decision makers, look to those agencies that have expertise with respect to listed species and critical habitat. And it primarily covers existing farming footprints in Washington, which is it's a historical activity in Washington. It's been around shellfish farming for a very long time. It also covers some new farming areas, and there's a set of conservation measures and terms and conditions that must be complied with if you rely on that programmatic consultation to obtain your permit. So if you get a permit from the Corps that relies on the programmatic consultation, there's sort of a good handy reference that's called Enclosure 1 that has conservation measures and terms and conditions from those programmatic biological opinions, and you need to comply with those in your project. The consultation also sets incidental take limits for acreages for certain activities, number of entanglements. And the Corps and the services monitor the implementation of the programmatic over time through at least annual meetings. And so as of the last annual report, none of the take limits were close to being reached. Interestingly, the cumulative total of authorized acres since 2016, it hasn't gone up every year. There's actually been some declines. And there's a variety of reasons for that, but it's been interesting to track. Most growers have used programmatic consultations for permitting. Individual ESA consultations are also an option. The programmatic consultation expressly excludes a subset of activities that if a grower is doing one of those things on their farm, they may need an individual consultation. The programmatic is intended to be a reference there, so you hopefully don't have to start from scratch when you're doing that individual consultation. And I think we've seen that implemented pretty well in a number of instances. And then lastly, habitat conservation plans, or HCPs, under Section 10. This is not a commonly used vehicle, but it is a potential option. In the Pacific Northwest, we more commonly see those in the timber context is where they have really been utilized, but they are a potential option. It is a pretty burdensome process. And I don't believe there's a HCP that's actually been completed, just to clarify that. So I'll turn next to recent rulemaking under the Endangered Species Act. And both of the services completed ESA rulemaking updates to their rules in April of last year. Those included changes to Section 4, Section 7, and Section 4D. I'll just give an overview of the changes that were made. So some changes to Section 4, that listing and critical habitat. There were 3 changes to the regulations addressing listing and 2 for critical habitat. The first is just clarifying that economic impacts are not one of the things that can be considered as part of listing. There's been some, I think, kind of movement back and forth on that through administrations. This new rule has a provision that says economic impacts are not to be considered. Some minor revisions to the concept of foreseeable future. So how far out do you look to think about threats and species response? So some changes there, clarification that the services are supposed to make reasonably reliable predictions, or the action agency. The standards for delisting too, there were some changes made there of when a species could be delisted. Then for critical habitat, the first is there are instances where it's not prudent to designate critical habitat. There's a list of examples in the regulations, and some of those were removed as part of the rulemaking. So if you have a species where the threat can't really effectively be addressed through Section 7, that was removed. And then if the secretary otherwise determines that it's not prudent, that was taken off the kind of enumerated list as well, but the list itself isn't exclusive. And then lastly, unoccupied critical habitat designations. So the revised rule has a process where if you're designating critical habitat, you start with areas occupied by the species at the time of listing. And then you can identify, the service can identify specific areas outside of that geographical area that are essential for the conservation of the species. And that determination has to be based on the best scientific data available. Just briefly on Section 4D, this was a Fish and Wildlife Service rule only. And it reinstated what's known as the blanket rule. So that's sort of an automatic kicker that if a species is listed as threatened, the protections for endangered species have an automatic application to threatened species. And that was there, and then it came off and was added back in this latest round of rulemaking. The different administrations have changed the rules, over time, over the last few administrations. Section 7, interagency cooperation, that's the Section 7 consultation. So some changes to the effects of the action, which some language was added to include effects caused by the action, but not part of the action. Some changes to the environmental baseline, where you're looking at what the effects of the proposed action is. There's a distinction made now in the rule language that looks at whether the activity is within the action agency's discretion to modify, and that can determine whether something's part of the baseline or not. It's a little unclear how that's going to be implemented, and I think folks are kind of waiting to see, if courts or the services provide some more clarification there. Then reinitiation of consultation, that's only can be done by the action agency, not by the services, although the services can recommend it. So that change was made. And then just this last bullet I'll spend a little time on, because I think it's the thing that nationwide and not in the aquaculture context, but kind of around the country, different kind of regulated sectors, there's been a lot of attention on this one. And this, I mentioned earlier when I was going through the framework of Section 7. This change authorizes the services to specify offsets or mitigation requirements as part of the reasonable and prudent measures that are included in a biological opinion in an incidental take statement. The services in the rule, the Federal Register notice, there was a lot of discussion about providing some more clarity in an updated Section 7 consultation handbook. That was last updated in 1998, so it could really use some updates. That has not happened yet. So that is still, potentially forthcoming, I think, updates to that handbook, which a lot of folks would find useful, I think. Just a little more context on this topic of requiring mitigation. The rule did change the circumstances under which mitigation can be required, but mitigation under the Endangered Species Act is not a new concept. Folks may be familiar with the concept of conservation banks. These are typically for terrestrial species, but not in all instances. The conservation banks have been around for a very long time. So banks restore and protect habitat for species that then they're approved by the agencies to generate credits. And if you have impacts, you can purchase credits to offset those impacts. Recently, the services have taken some action kind of as a precursor to rulemaking to issue some more formal mitigation policies for the way that the service agencies approach mitigation. The policies didn't change, kind of existing authorities were not sort of rulemaking level changes. This is more about the agencies working to formalize their mitigation approach and make it more consistent. So both NOAA and Fish and Wildlife Service issued mitigation policies. For NOAA, it was the kind of the first agency-wide mitigation policy that had been issued. That was followed by a pretty detailed set of procedures from NIMS on mitigating impacts to trust resources. And then Fish and Wildlife Service issued a general agency-wide mitigation policy, as well as a one specific to the Endangered Species Act. Looking at how some of these mitigation approaches in a more formalized way have been implemented on the ground, there are a couple of examples from Washington State. One that's more on the East Coast that I'll reference. That's kind of the one here that's specific to aquaculture, shellfish aquaculture, and then another one that I just learned about recently, so haven't been involved in. The first is the Puget Sound Nearshore Conservation Calculator that was developed by NOAA Fisheries to calculate debits, mitigation impacts, and then kind of what your mitigation obligation was for some typical nearshore projects. So things you see in the photos here, bulkheads, piers, more at sort of the residential scale. That's been in place for a while. The ports that were kind of getting their projects going through the calculator were really finding it didn't work well for a bigger scale. So a couple of ports in Washington, Port of Seattle and Port of Tacoma, have developed their own calculator that's a little different. That calculator has been applied in some growers have dealt with it in their nearshore projects. You know, if they've had to replace a dock or a bulkhead, for example, and in very, very limited instances to shellfish aquaculture. Something that's been interesting, might be interesting to folks if they're not aware of it, that's come out recently on the East Coast, is looking at the ecosystem services kind of beneficial effects of shellfish aquaculture and trying to quantify that ecological uplift. That's scientists from the Northeast Fisheries Science Center and the National Centers for Coastal Ocean Science created an online tool for oyster growers in the Northeastern United States. They can use it to get a science-based estimate of how much nitrogen their farms remove from local waterways. There's a calculator then that generates a report that growers can include in their aquaculture permit applications. And then finally, this is some mitigation work that's been happening under pesticide application and registrations. NIMS and EPA are working on developing a mitigation framework there. ESA litigation, I'll just cover at a very high level a few recent decisions. These three are really focused on challenges to the recent rule, the Endangered Species Act rulemaking that was done, as well as imposing of mitigation requirements. So the first two cases are challenges to the rule. One's by the National Hydropower Association. It's out of DC. The second is the Center for Biological Diversity, and that's in the Northern District of California. Both of them include challenges to those ability to require offsets as part of reasonable and prudent measures. But the Center for Biological Diversity case has been going on for quite some time. It includes a challenge both to the 2019 and 2024 rules. And one of these cases sort of argues, hey, services, you went too far in exceeding your authority and allowing offsets. And the other case sort of comes at it from the other side and says you've not been adequately protective of the species. So those are both early on in litigation. Opening briefs are due in the next couple of weeks. Those will just we're watching to see how those shake out. The third case here is one that's based in Washington and is a challenge to reasonable and prudent mitigation requirements in a specific jeopardy biological opinion that was issued for a 100-year-old tide gate replacement. And that those mitigation requirements were based on the calculator. Pacific Northwest Waterways Association has filed an amicus brief, and there's a lot of attention being paid to this case for a variety of different user groups that are potentially affected. These are all early on in the litigation process. And lastly, just some recent decisions that are ESA related from around the country that I'll walk through just at a high level. The first is the Maine Lobstermen's Association versus NIMS. That was a challenge to a biological opinion and an incidental take statement related to the northern right whale. And it addressed what's known as the precautionary principle. So if there's sort of not a full body of scientific information, you can apply what's known as the precautionary principle, which is a substantive presumption in favor of protected species. In this case, held that the Endangered Species Act does not require a substantive presumption. So that has gotten some attention. NRDC versus Halen. This is out of the Ninth Circuit, so on the West Coast, that looks at the kind of what you have to show to challenge a biological opinion, what science you need to put forward. And the decision there held that the agency, the science that is presented must be essentially better than what the agency relied on. That discarded science would have to have made a difference in the ultimate result. So that has raised the raised the bar in terms of what you need to show to challenge a biological opinion. Next is Loper Bright versus Raimondo. That's a Supreme Court decision that struck down what's known as Chevron deference. Folks may be familiar with this principle. It's been around for a long time, and it applies a test that essentially, if you're in a situation with an ambiguous statute and you have an agency that's interpreting it, that agency has had longstanding deference in their interpretation of a statute that's not clear on its face. And Loper Bright changed the framework there to, rather than giving deference to agency statutory interpretations, the inquiry is broadened, so the court looks at and considers everything available and determines the best reading of the statute in what's known as a de novo review. This is getting litigated now in a lot of other cases, so there'll be more to come on kind of how that standard is further defined and refined. Lastly, the Center for Biological Diversity versus Regan. This was a case that dealt with the delegation of 404 permitting under the Clean Water Act to the state of Florida. If there are any folks on the webinar from Florida, I believe there are. You may have been following this one. Essentially, just on the Endangered Species Act side of the case, it was a challenge to an approach that was taken to do a programmatic biological opinion that the intent was to provide some upfront coverage for future permittees that received 404 permits from the state of Florida. And then that decision did not uphold the programmatic BiOp. So the challenge was successful. There are other proposals to delegate federal permitting to states that are out there and being considered. It was something that the Trump administration pushed as an approach and advocated for in the first administration. So there'll be more to come on that delegation process as well. I'll just lastly touch on the administration transition. Charlie and I decided to set this webinar for sort of both after the election and after the new administration has come in. We set it back in the fall when we didn't know what the outcome would be, but just thinking that it might be helpful to provide some thoughts on maybe what's happening right now, what's on the horizon. So I'll run through a couple of topics there. The first two are things that have already happened to some degree, and I'll touch on. The other three are things that might be expected to happen. I'll say there is some transition that happens with every change in administration on a lot of these bullets, and that is sort of the standard course of business. Some of what has happened to date is, however, rather unusual. So it is an indication that there's more things to come that are sort of out of the typical course of a transition in administration. The first, a couple of executive orders that have come out in the last 10 days. These are more directed at energy, national energy emergency, the management of California's water. So they're nothing to do with aquaculture. As are quite a few things I've raised today, not really specific to aquaculture, but more about what's happening with ESA generally. But something that the executive orders did that's garnered a lot of attention is invoking what's known as the God Squad. It's officially named the Endangered Species Committee, and it's a provision of the ESA that's been in place. It was created in 1978. So it gives this group the authority to convene and exempt an agency action from the requirements of Section 7 if 5 out of the 7 members vote in favor of exemption. And it's the Secretary of Agriculture, Secretary of the Army, Chairman of the Council of Economic Advisors, Administrator of EPA, Secretary of the Interior, NOAA Administrator, and an individual from the affected state. A federal agency, a governor, or in some circumstances, a permit or license applicant can submit an application for consideration. This has been in place for a long time. It has only been, the God Squad has only been convened and ruled 3 times. It's only ruled 3 times since its creation. 1 exemption was denied and 2 were permitted. So it's a very, very rarely used provision. And the executive order declaring a national energy emergency directs the Interior Secretary to convene the ESA committee not less than quarterly, unless otherwise required by law, to consider applications that are in front of the committee. And if there are no applications, then identify obstacles to domestic energy infrastructure related to the Endangered Species Act or the Marine Mammal Protection Act. And that's just, I think it's just an example of, even though it's a provision that's been in place for a very long time, using an executive order to direct a pretty dramatic departure from prior practice in terms of how it is implemented. There's a lot of questions about how and whether that can be done. That'll be taken up in due course and through the different mechanisms where these things get considered and challenged. But it is an example of something that's pretty out of the ordinary that's already happened to date. Changes to the federal workforce. There have been some pretty high level reassignments of career folks already at a number of agencies, offers of buyouts, return to office mandates. So it's not clear what all effects this will have, but it certainly is a pretty significant set of directives that is causing, for folks that are active in permitting processes and kind of different, used to engaging with folks at agencies, it's a pretty significant departure. And there may be some shakeups. I personally am seeing it from federal employees, within my family, from colleagues. So that is just something that's out there as well. And then the last 3, ongoing litigation, rulemaking and policy changes, and the Section 7 consultation handbook's one example. But presumably the United States will reevaluate its position in ongoing litigation. the rulemaking policy changes, the pendulum has shifted with the Endangered Species Act and a lot of other laws through different changes in administration. I think we can see that is likely to happen here. So many of the things that I've talked about today, it may be a very different presentation a year from now. And then the Section 7 consultation handbooks, maybe just one example there. I'm aware there's a draft of that handbook that's been prepared, but I don't know if and when it will ever be released in its current form. So that's just a kind of a rather specific example related to ESA, but upcoming opportunities, there's just one I wanted to call out here. I think most folks on this webinar are probably aware of this already, but in case you're not, NIMS Aquaculture is hosting a webinar on February 18th that's titled Understanding the Endangered Species Act, Species Listings and Protections. The time that's on here, I'll just call out for folks' attention, is Pacific time. Check from wherever you're located, make sure you have the time right if you sign up. But the link here is not active. This is just a screenshot, but it is available online, and I think NA has all the information as well. So that's something else for folks to be aware of. And that concludes my presentation. I think we've got some good time here, Charlie, for some Q&A if there is any.
Excellent. Well, thanks so much, Amanda. That was extremely interesting and educational for me. Folks, if you want to raise your hand, we could take you off mute if you have a comment or question for Amanda. We have about 10, 15 minutes left. And in the meantime, I will say, yes, the NIMS webinar is on NA's event calendar. If you go to our homepage, you'll find that there and a link and everything else. One question while we're waiting, Amanda, the Puget Sound mitigation calculator, have you heard that being considered in any other areas of the country? Like new calculators being implemented in the Atlantic or Gulf?
No, not that I'm aware of, although I think the work that's being done around pesticide registrations, that's something I recently saw a presentation on, that is kind of broadly just under FIFRA. It had a set of actions that could be taken that would result in the kind of different point scores. So if you took certain actions like planting hedgerows or buffers or things like that, that would qualify, to kind of buy down your obligation or address it. But yeah.
Okay.
I haven't, for folks that aren't aware of it, or if it's not on your radar, I think the calculator that was done for shellfish aquaculture, that aquaculture nutrient removal calculator, is really interesting. And that was something that's out of the northeastern United States.
Hey, let's see. I have one, Ganesh in the comment box just pointed everyone to a potential economic impact of U.S. aquaculture of injurious species listings with a link there. Thanks, Ganesh. And Brian, I'll go ahead and ask you to unmute.
Yeah, thanks. Hi, Amanda. Hope you're doing good.
Hey, Brian. Hope you are as well.
Yeah, well, it's rainy and windy, but other than that, everything's good out here. That's a life as you know it. So,
Yeah.
just wondering, I maybe I misunderstood this, but you were talking earlier about some changes to the services we're making, and one of them, did you say that they were doing something that would allow them not to consider economic impact on a listing?
Yeah, and I'm gonna see if I can pull up, because I've got it handy here, just the revised language for you. That is in the rulemaking, and it is addressed specific to listing. So bear with me just a minute here.
I'll go ahead and mute myself, but thanks for the answer ahead of time.
Yeah, yeah. Yeah, so it was a reinstatement. It's 50 CFR 42411B. And the language that was added, this, so it's the secretary shall make any determination required by paragraph C, D, and E of this section solely on the basis of the best available scientific and commercial information regarding a species status, without reference to possible economic or other impacts of such determination. And that without reference language is the reinstatement language.
Okay, we had another question in the chat box. Do you have any updates on the listing for the Sunflower Sea Star?
I don't. I don't. It was listed as proposed in 2023, so it's something we've been, kind of watching to see what would happen, but I haven't gotten any updates about the listing itself.
Still have time for some questions. In the meantime, I'll fire away with one more. There are clear time clocks built into the ESA for listing a species. Petition for listing with 90-day public comment and then a 12 months to make a decision. But we often see the 12 months decision process stretched out for years. I think you just mentioned the Sea Star is 2023. How is the agency able to kind of punt and delay decision making beyond the rule 12 months? So.
Yeah, good question, Charlie. And it's not something I've dealt with directly in the ESA process, kind of in terms of a challenge to deviation from a timeline in the ESA context. You are right; these things can often go sort of beyond the timelines that are listed in statutes. It's also something that I think has it's gotten a lot of attention in the wetland mitigation banking context. So there are some timelines within the compensatory mitigation rule under the Clean Water Act for the certification of wetland mitigation banks. And there have been a lot of challenges with the, proposed bankers having their banks going through that certification process can often take much longer than the timelines that are set forth. So I think there as far as I'm aware, hasn't been a sort of successful challenge to, you must stay within these certain timelines for these actions, even if they are set forth in statute or regulation. So I'm not familiar with the ESA timeline specifically, if there is any, carve out or qualification in the language of the regulations themselves. But even if there isn't, I think those timelines, certainly, there's a lot of instances where things have taken a lot longer than anticipated. And I don't know if that particular topic has been litigated offhand.
So it may be that just no one's kind of challenged the delay.
Yeah, that may very well be the case, or challenged it, in litigation. I think often the challenges to timelines in litigation don't always, meet with meet with success, but sometimes they do. And it is something that I think, the Corps has done a lot of work internally to try and improve those timelines. And that's been through a series of, work that I think bankers have worked with, folks in Congress, with folks at the Corps to try and see how those timelines could maybe be improved upon. There have been studies that have been done by universities to see sort of, at different stages in the process. And the Corps last year, I think it was last fall, issued a memorandum and some directives to districts about how to go through the process and kind of hopefully adhere more to the timelines. That was pretty detailed. So there is, I am aware of some work that's been done, in a different context to around timelines, and I do think that has met with some success. So
Okay, good to hear.
yeah, I'd be glad to talk about that more, offline, if anyone was interested.
Great. Well, folks, we have time for one or two more questions. So you've got a legal expert here donating her valuable time. If you got any questions, I'm sure Amanda's happy to field them. In the meantime, I'll just mention, our upcoming webinars. We've got a 2025, our calendar's packing out. On February 20th will be our next NA webinar. Look for that announcement next week. We'll have Chip Terry with Blue Trace talking about the Food Safety Modernization Act and traceability standard updates that impact seafood. So that should be another really good one. And yeah, if you're not familiar, we'd really invite everybody that enjoys these webinars and finds value in them to join the National Aquaculture Association. If you're a farmer or supplier, I'd be glad to talk with you and tell you all about the benefits. And for any of the public service staff that are on, we do offer a non-voting student and public service membership as well at a greatly reduced rate. So really invite you to join and support the National Aquaculture Association. Any last minute questions for Amanda? All right.
And
Well, I think we'll wrap it up. So
yeah, and Charlie, if I think I had my email address there on the first slide and a just kind of general phone number here for the office at the bottom. But if anybody wants to reach out over email, that'd probably be the best way to do it. And I'd be glad to connect with anybody offline if there's follow-up questions.
awesome. Well, that's great. So we really appreciate your time. It's like a unicorn finding legal experts working in the aquaculture space. We appreciate all your investment today and all the work you're doing to help farmers around the country too. So
Thanks for having me, Charlie, and to NAA. And it's been an absolute pleasure and honor being able to work with the growers I've worked with since 2006. I feel very, very lucky and fortunate to do the work that I do.
awesome. Well, we sure appreciate it too. All right. Well, we're going to wrap it up. Everyone have a great Friday and a good weekend. And hope to see you on our next NA webinar in February. Take care, everybody.